Hello, and welcome to Barcast Audio. This is our corporation's essay workshop. This workshop is designed to help walk you through a corporation's essay as tested on the bar exam. For our example, we're going to be walking through an original corporation's essay drafted in the style of the multi-state essay exam. I'll begin by first reading the question. I take special care to note to yourself any issues and facts that stick out to you as I'm reading through. I suggest you rewind and listen through the question twice before attempting to tackle it. All right, so without further ado, let's jump into our corporation's essay workshop. A shareholder owns 100 shares of a publicly traded corporation named Major Inc. Major is incorporated in State X, which has adopted the Model Business Corporation Act. The shareholder read a tweet from a major financial news outlet reporting that Major had entered into agreements to open new factories in Country A. According to the story, Major had paid large bribes to Country A's government officials to seal the deals. If made, these bribes would be illegal under U.S. law, exposing Major to significant civil and criminal penalties. On April 1, this shareholder sent a letter to Major asking to inspect the minutes of meetings of Major's board of directors relating to the Country A factories mentioned in the tweet, along with any accounting records not publicly available that are relevant to the alleged foreign bribes. The shareholder explained that he was seeking the information to decide whether to sue Major's directors for permitting such possible illegal conduct. In his letter, the shareholder also demanded that the Major board investigate the possible illegal bribes described in the news story and take corrective measures if any illegality had occurred. On May 1, Major responded to the shareholder in a letter which stated, quote, "The corporation will not give you access to any corporate documents or take any action regarding the matters raised in your letter. We cannot satisfy the whim of every major shareholder based on unsubstantiated tweets. Furthermore, given our continuing operations in Country A, the board of directors will not investigate or take any other action regarding the matters raised in your letter because doing so would not be in the best interest of the corporation." End quote. On September 1, the shareholder filed a suit in State X court. His petition includes 1. A claim against Major seeking inspection of the documents previously requested, and 2. A derivative claim against all of the Major directors alleging a breach of their fiduciary duties for failing to investigate and take action concerning the foreign alleged bribes. Major's board of directors has asked the corporation's general counsel the following questions. 1. Is the shareholder entitled to inspect the documents she requested? 2. May the board obtain dismissal of the shareholder's derivative claim if the board concludes that it is not in the corporation's best interest to continue the lawsuit, even though the board has not investigated the allegations of illegal foreign bribes? 3. Is the board's decision not to investigate or take further action with respect to the alleged illegal foreign bribes consistent with the director's duty to act in good faith, and is that decision protected by the business judgment rule? How should the general counsel respond to these questions? Explain. All right, so now that we've read through the essay, which issues stuck out to you, take a moment and try to think what the issues were, try to identify what the facts were. I suggest you go back and listen to the hypo again, just to get in the practice of identifying these facts and issues as you're reading or listening through that. All right, so what jumped out to you? The first issue that should have jumped out to you here is the idea of a proper purpose when it comes to a shareholder inspecting Major's board's minutes and accounting records. The general rule to remember here is that a shareholder has a right to inspect and copy the records of a corporation during normal business hours as long as they give 5 days notice and state a proper purpose. A shareholder seeking inspection of corporate documents must offer credible evidence that there was mismanagement or other improper conduct. Okay, so now we have the rule. You may not have known that rule cold off the top of your head, but that is the rule to know here. And as you practice, you'll start to really nail down these pure black letter law rules. But how do we connect the facts here of the hypo to this rule statement now? So first off, the shareholder wrote the April 1 letter and stated explicitly that he wanted to inspect these materials because he was deciding whether to sue Major's directors for permitting such possible illegal conduct. Moreover, here, the shareholder could cite the tweet of the prominent financial news network as credible evidence of the improper conduct. Major's May 1 letter characterizing this tweet as unsubstantiated is not enough to dismiss the tweet as not credible. Notably, this letter did not deny the allegations of improper conduct whatsoever. They didn't say anything about this being wrong or unfactual. They just said that they weren't going to entertain the whim of every shareholder. Therefore, the shareholder would have a right to inspect both Major's minutes and accounting records in connection with the alleged bribes of Country A's officials. Let's move on now to issue number 2, the shareholder's derivative claim against Major. The general rules, remember here, is simply that a shareholder may bring a direct or derivative claim against the corporation in which the shareholder owns stock. In a derivative action, a shareholder brings suit on behalf of the corporation and is typically based on a breach of fiduciary duties by the board of directors. In order to bring a derivative action, the shareholder must have 1, standing, and 2, must make a written demand upon the board of directors. Now, when does a shareholder have standing? Sort of a longer, chunkier rule here, but to have standing, the shareholder must have been a shareholder at the time of the wrong and at the time the action was filed and continue to be a shareholder throughout the litigation. Generally, a board can bring a motion to dismiss the derivative action if 1, it is acting in good faith, and 2, it is acting in the best interest of the corporation. So a lot to unpack there, a meatier rule statement. Now we connect our rules and now we score some points. Here, the shareholder filed a valid derivative action because he made a formal written demand on April 1 and was a shareholder at the time of the alleged wrongdoing by Major. Nothing within the facts indicates that he stopped being a shareholder at any point throughout this short litigation. Here, given the apparent lack of any inquiry or corrective action by the board, as evidenced by their May 1 letter to the shareholder, the court should not grant the motion to dismiss the derivative action or accept the board's conclusion that proceeding with the lawsuit would be contrary to the corporation's best interests. Let's move on now to point 3, the business judgment rule. It explicitly tells us that's what's being tested. Shouldn't be too much of a curveball, but what is the general rule for the business judgment rule? The business judgment rule is a rebuttable presumption that a director reasonably believes that his actions were in the best interests of the corporation. However, the business judgment rule does not generally apply to a conflicts of interest transaction. That second sentence is important to include here, even if it doesn't necessarily apply directly to the facts here, just because it's very helpful to flesh out the rule and possibly allow you to score more points. In order to overcome the business judgment rule, a party must demonstrate that 1, the director did not act in good faith. 2, the director was not informed to the extent that the director reasonably believed was necessary before making a decision. 3, the director did not show objectivity or independence from the director's relation to or control by another having material interest in the challenged conduct. 4, there was a sustained failure by the director to devote attention to an ongoing oversight of the business and affairs of the corporation. 5, the director failed to timely investigate a matter of significant material concern after being alerted in a manner that would have caused a reasonably attentive director to do so. Or 6, the director received a financial benefit to which he was not entitled, or any other breach of his duties to the corporation. Remember, this rule, you don't have to prove all 6 elements, you just have to prove one of them. It's an either-or situation, not and. Here, the shareholder could likely argue that Major directors did not act in good faith because they allowed Major to engage in illegal conduct by way of bribing foreign officials of Country A. Further, the shareholder could rightly argue that the Major directors failed to timely investigate the allegations of impropriety following the news report and shareholders' April 1 letter, as nothing within the facts here indicates that the corporation took any corrective measures whatsoever to investigate these issues or correct them. Directors who are not acting in good faith are not afforded the protections of the business judgment rule. Thus, the directors of Major would not be protected under the business judgment rule, as they failed to act in good faith by allowing Major to engage in illegal conduct in Country A and failing to investigate the reports of same. This concludes the last of the 3 major issues, and it concludes our corporation's essay workshop. This has been a production of Barcast Audio. Be sure to check us out at barcastaudio.com. We have audio lectures, audio flashcards, all the materials you need to pass the bar exam. Until later, I will talk to you guys soon now. Bye now.